Hey there! Let's talk about something a lot of us tend to put on the back burner, making a will. Specifically, we're going to break down how to create a formal will right here in Alberta, and I promise we're going to show you just how simple it can be. Let's jump right in.
So let's start with the big question, the one that gets this whole conversation started. When you're no longer around, who gets to decide what happens to everything you've worked for? You know, your house, your savings, all those little things that mean so much. If you don't make a choice, well, someone else will.
And that right there is the absolute bottom line. Without a will, the government has a one-size-fits-all set of rules that kicks in to divide up your stuff. A will, on the other hand, is your voice. It's your personal instruction manual that lets you call the shots and puts you squarely in the driver's seat.
Okay, so where do we even begin with all this? Well, let's start with the absolute bare essentials. It's way simpler than you probably think. In fact, it all boils down to just two fundamental rules to make a will valid.
That's it. Just two. Once you strip away all the legal jargon and the complications, there are really only two things that are completely non-negotiable.
And here they are. First, it's gotta be in writing. We're talking a physical document here, something you can hold. And second, you have to sign it. That signature is your stamp of approval, the thing that says, yep, these are my final wishes. Pretty straightforward, right?
And here's some really good news. And honestly, this is a myth that stops a lot of people in their tracks. You don't actually need a lawyer to make a basic formal will. You can absolutely do this yourself, which can save you a whole lot of time and money.
All right, now for what I like to call the main event, the signing ceremony. This is the moment your will comes to life legally. And believe me, the rules here are super strict for a very, very good reason. Everything has to be just right. Now, what's really interesting here is the mix of flexibility and this one giant warning. So you have to sign it, or you can have someone sign for you, but they have to be right there with you when you tell them to. And get this, the signature doesn't even have to be at the bottom. But, and this is so important, the second that ink hits the page, that document is locked. Anything you try to add after the fact, it just doesn't count.
This brings us to the absolute core of making a formal will, the two-witness rule. It's like a carefully choreographed dance. First, you sign it while your two witnesses are watching, and they both have to be in the room at the same time. Then, while you're watching, they both sign it. It all has to happen in one continuous sequence.
So what on earth does "in the presence of" actually mean? Well, the law calls it the rule of sight, and it's pretty literal. It means you, witness number one, and witness number two all have to be able to physically see each other put pen to paper. No signing in different rooms or coming back later to finish up.
Of course, technology has changed things. So while the classic in-person signing doesn't require a lawyer, signing remotely over a video call has one giant non-negotiable rule. It is only, and I mean only, allowed if a lawyer is actively involved in giving you legal advice for that specific will. You can't just get your friends on a video call and do it yourself. That will not work.
All right, we've nailed down the legal formalities. Now let's get into the heart of the matter, the actual instructions. This is where you tell everyone who gets what. First things first, this is a vital piece of legal housekeeping. Your new will needs to have a sentence in it that clearly says it cancels out or revokes any other wills you might have made in the past. This is super important because it prevents any confusion and makes sure this new will is the only one that counts. Next up, you need a manager for your estate. This person is called the executor, or sometimes a personal representative. Think of them as the person you trust to step into your shoes, gather everything up, pay off any bills, and then make sure all your instructions are followed perfectly. And here is a pro tip that can save your loved ones a massive headache down the road. Don't just pick one executor. You know, life happens, so name your first choice, your primary, and then name at least one backup, an alternate, just in case your first pick isn't able or willing to do the job when the time comes. Now for the fun part, giving things away. Now, the legal word for a gift in a will is a disposition, and as you can see, there are fancy terms for different kinds of gifts. A bequest is just a gift of money. A legacy is a specific personal item, like your watch, and a devise is for real estate, like your house. So after you've made all your specific gifts, the house to your daughter, the watch to your friend, what about, well, everything else? That's what we call the residue. It's the catch-all category for whatever is left in the pot after all those specific gifts have been handed out and the debts have been paid. And this brings up a really, really important question.
This is maybe one of the most common and costly mistakes people make when they're writing their own will. What happens if you forget to say what to do with all that leftover stuff?
The answer is simple. You lose control. For that forgotten chunk of your estate, it's as if you died without a will at all. Those old government rules, the law of intestacy, they jump right back in and decide who gets the rest. And that might not be what you wanted at all. So always, always have a residue clause.
We're in the home stretch now, so in this last section, we're going to cover a few really critical warnings to help you avoid some major pitfalls, and then we'll talk about what to do with your will once it's all done.
Okay, please let this one sink in. If you remember nothing else from this explainer, remember this. A gift to your witness is a canceled gift. The law is completely black and white on this. The person who witnesses you sign your will cannot also be someone who gets something in your will. If they are, their gift is just gone, voided.
And this rule, it casts a pretty wide net. It applies to the witness themselves, their spouse or partner, and even the person who might have signed the will on your behalf. Now, there is a tiny exception if you have extra witnesses, but honestly, the simplest, safest, easiest path is always the same. Pick witnesses who get absolutely nothing from your will.
So you've done all the hard work. It's signed, it's witnessed, it's legit. Now what? Well, you've got to keep it safe, right? Somewhere like a fireproof box or a safety deposit box. But the most important thing? Make sure your executor knows exactly where it is. A perfect will that can't be found is totally useless.
And that brings us to our final thought. A will is not a set-it-and-forget-it kind of document. Think of it more like a snapshot of your life at one specific moment in time. So, what happens when life changes? You get married, you have kids, your whole financial picture shifts. That's the question you always have to keep in the back of your mind, because a will that's up to date is really the only one that can truly protect the people you care about.